Hello, everybody.
All right, this is 24S31985 FH versus Kirian and Vaughn. Ms. Lyons, have you had an adequate opportunity to review the pre-sentence report and the sentencing information with your client?
I have, Your Honor.
Additions, corrections, or deletions?
Appears accurate as drafted.
All right, and then does your client consent to being sentenced remotely?
Yes, Your Honor.
Okay. Ms. Bilg, anything on behalf of the people?
No additions, corrections, or deletions to the report. We respectfully request that you honor the recommendation. I believe it was 2 years of probation, beginning with 6 months in jail for credit, with credit for 87 days served. I do believe that is appropriate, especially the fact that we have no objection to her release directly to an inpatient rehab facility, considering that there is a considerable history of substance abuse and an escalation thereof. So we would ask that you follow that recommendation. Thank you.
Ms. Lyons, what do you have on behalf of your client?
Thank you. As it relates to the recommendations, Your Honor, we do think they're appropriate under the circumstances. My client is asking that you follow those. The only, I guess, missing information that we don't have is a referral was made to the adult recovery court, and I've not heard back on that to know kind of where that stands. If for some reason, I do know that she presently doesn't reside in Montcalm County, but her intent was to reside in Ionia County upon release from incarceration, which I think would allow her to still be supervised locally. So if it's an option, she certainly would not turn that down, Your Honor. If it's not an option, she is asking the court here to consider allow her, when appropriate, a release to inpatient treatment. In talking to her, it seems apparent that she is thankful really for her stay at the Montcalm County Jail. I think it's kind of opened her eyes a bit in terms of where she's at in her life. What is kind of unfortunate about this is I've had a chance to get to know Carrie Ann, and she's an intelligent young woman. Had some college education along the way. In her statement to the court, I thought she was very concise about her needs and what she thought was appropriate. It's really one of the more concise, complete statements that I've read from a client, and I think she recognizes that she is in a bad way. And I at least am optimistic about that. Certainly, Judge, where she struggles would be things like resource management and those types of things. But I think that she is certainly, as she sits in jail, recognizing that that's a struggle that she has, and is connecting with her appropriate community supports as to what things would look like upon release. So I am asking that you follow the recommendations. I think they're appropriate here.
So Ms. Vandereen, can you shed any light on that? I did see part of the agreement I read in the PSI was, I guess there was no objection to a referral. But then I don't remember reading anything about what happened with you though.
Correct. So at the time of plea, it was indicated that she's not a good candidate, so that they would consider her. And talking further with Agent Chabin, she expressed that, again, she was not a good candidate. She was asking about the alternatives and how much jail she would serve if she did do the program. And then when I saw her, she had reported not using meth since 2022. So at this point, she's not, it doesn't sound like she's ready for treatment.
It doesn't sound like she's being honest.
Correct.
Well, there you go. Ms. Lyons, anything else?
The only thing I would note about that, Your Honor, I mean, you know, I'm not sure when adult recovery court met with her. I think it was early in her stay in incarceration. She's now been there for at least an additional month and a half. And so I think sometimes that can help a person recognize perhaps where they're at. So that would be my only counterpoint to that. But
are you suggesting that jail is sort of like a truth serum?
I think I am, Your Honor. I mean, at least in a it certainly makes one take stock, I think, of the choices that they've made. Certainly the pause that Ms. Vaughn has had in jail, I think has been a good thing for her. And I think she would acknowledge it's been a good thing for her. So,
Well, let's see what she has to say. Ms. Vaughn, anything that you want to say before the court imposes a sentence?
That I am recognizing that things need to change, and I know how to do it differently. And I would love a chance to prove that. And then I'm hoping to go with the recommendation so that I can prove to that.
All right, well, Ms. Vaughn, I'll tell you right now, I can cut to the chase. I'm gonna follow the recommendations here. I think they're appropriate. However, it certainly does cause everybody some concern when it seems on its face that you're not being truthful with folks. You know, what you were found with when you were stopped would suggest distribution of drugs, frankly, when you have scales and baggies and all of that. And that you're far deeper into this than maybe even just a user. I don't know. I guess time will tell. But to the extent that there is a problem, certainly you don't need the drug court to fix your problem, right? Sometimes we think, because that's what we hear, it's always drummed in the media, that specialty court will fix me. Specialty courts don't fix anybody. You have to fix you, right?
Correct.
And people became clean and sober long before the advent of any specialty courts. I don't have any doubt that the public and most folks believe that, right? Because it's out there so much that I can't get clean without a specialty court, but that's just simply not true. You hold the power to that. And frankly, when I read through this PSI, if your 8-year-old son doesn't motivate you to get clean, I can't motivate you. The drug court can't motivate you. Nobody else can. You've got to do that. All right. So I don't know what the status is if I'm reading through the PSI of your 2 15-year-olds and the 17-year-old, and I don't know if their motivation for you, but it certainly seems like Bryce's motivation for you. So if you want to get clean, you can get clean. All right. I'm going to place you on a period of supervision for 2 years. I'm not going to go over all the terms of your supervision. I will adopt all 31 of them, but I'll cover the ones that I think are most relevant. First, we'll start with substance abuse evaluation. We'll follow all the terms of that. Obviously, there'll be no drugs or alcohol while you're on supervision. You'll be tested randomly the same for those substances. I'm going to require that you maintain employment of at least 30 hours a week or a combination of your employment and your supervision obligations. We'll have a curfew between the hours of 10 p.m. and 6 a.m. Excuse me. While you're being supervised, ma'am, those supervision fees are going to be $30 per month. There's a $60 DNA testing fee. I'm required by statute to impose a state cost of $68. I'll do that. Also required by statute to impose a crime victims assessment, the amount of $130. There'll be court costs of $550 and a fine of $500, and then attorney fees of $400. As it relates to the jail, I'm going to impose the recommendation of 6 months in the Montcalm County Jail. You have credit for 87 days served, and then consistent with the rest of the PSI, I don't have any objection to an early release to treatment. However, I want that after we've served 4 months, all right, not before that. I want to make sure that we have at least a period of 90 days, and the 4 months will make sure we get there, of sobriety, i.e. jail time. And hopefully that will set you up on the right foot, so to speak, as it relates to taking advantage of that programming. Ms. Vaughn, you do have a right to seek appellate review, and if you'd like to do that, you have 21 days from today's date to make that request. If you want a court-appointed attorney to assist you, you have a broader window of 42 days, so 21 and 42. Anything else from either side?
Your Honor.
All right, you're all set today, Ms. Vaughn. Good luck.
Thank you.
Your Honor.
This case would be People versus Eddie. Betsy Hartley on behalf of the people.
Good morning, Your Honor. Kurt Richardson appearing on behalf of Gertrude Eddy.
Today's the date and time set for a status conference. We have worked out a resolution whereas the defendant will be tendering a guilty plea to domestic violence. And he would then agree to offer it under 7694A. Also, she will be tendering a guilty plea to CCW. That would be basically adjourned for 6 months, and if there's no issues, it will be reduced to an improper transport under 750.227D, which is the 90-day.
Okay, did you get all that, Ms. Vanderbeek? That's a lot. All right. So, Ms. Edie, raise your right hand and we'll have you sworn.
You swear or affirm the testimony you're about to give us the truth, the whole truth, nothing but the truth, so help you God.
All right. So, Ms. Edie, the charge in count 1 is a 5-year felony and/or $2,500 fine. There's also mandatory forfeiture of that weapon or device. And then count 2, domestic violence, is a 93-day misdemeanor and/or a $500 fine. Consecutive sentence can be imposed if the assault was committed in place of confinement. You understand the nature of those 2 charges and the maximum penalty?
Yes, it is.
All right. Do you understand? Oh, yeah, thank you. Do you understand that if you go forward with your plea, you won't have a trial of any kind? Is that what you want to do, is waive your right to have a trial to take advantage of what was announced on the record?
Yes.
Okay. When you waive your right to have a trial, you waive all the rights that come along with a trial. They're found on this form titled Advice of Rights. Is that your signature at the bottom?
Yes, it is.
Ma'am, did you have a chance to read this form over?
Yes.
Okay. Having read it, did you have any questions about your rights?
No, I don't.
Do you believe you understand them?
I do.
All right. Understanding them, are you waiving them in order to take advantage of this offer that's been worked out on your behalf?
Yes.
All right. 2 other things you'll be waiving that we need to talk about. By waiving your right to have trial, you'll also waive the right to claim at a later date and time that it wasn't your choice to enter a plea here this morning of February 27th. Do you understand that?
Yes.
You'll also be waiving the right to claim at a later date and time that there were other promises or threats or inducements to you, except those we've already placed on the record. Do you understand that?
Yes.
All right. Even with this plea, you have a form of appellate review available to you. It's called leave to appeal. And with that, you could hire an attorney, but if you could not afford one, the court could appoint one for you. Do you understand that?
Yes.
All right. You have any questions about anything we've done so far?
No, I don't.
All right, let's talk about those charges. How do you plead the charge in count 1 of carrying a concealed weapon?
Guilty.
And then how do you plead the charge in count 2 of domestic violence?
Guilty.
The information says that these crimes occurred on or about the 17th of January of this year in the township of Pearson in the county of Montcalm. Is that the correct date and location?
Yes.
On that date and location, could you tell me in your own words what you did to be guilty of those crimes?
I left my husband the day before and all day long I was getting threats. So I took the gun out of my house and he came home. I took it out of my house, put it in my car. And he came home and was blocking the doorway so I couldn't leave. So I pushed him out of the way and then I ended up leaving and he called the cops and said I had a gun in my car.
So you left with a gun?
Yes.
All right. And did you in fact have that handgun in the car?
Yes, I did.
All right. And I assume then you didn't have a valid concealed pistol license for that?
No, I don't.
Okay. And then what happened with the domestic violence then?
I pushed him out of the way of the door.
All right. And that's when you were leaving with a handgun?
I already had it in the car hiding it from him.
Okay. So attempting to get out, you pushed him.
Yes.
All right. And when you pushed him, was that meant to harm or embarrass?
No.
Help me out, counsel.
You agree when you pushed him, it was offensive contact that he didn't consent to, right?
So yes.
And he was your husband at the time, so you were in a
Yes.
dating relationship with him. And he didn't want to be pushed, but you pushed him, right?
Yes.
All right. Ms. Hartley, anything else on the facts? How about you, Ms. Richardson?
Satisfied.
All right, court will find a factual basis for 1 and 2. Ms. Edie, that means I'm back to you. Other than what we have talked about here this morning, has anyone else promised you or threatened you or done anything to you to get you out of this plea?
No, they have not.
Other than what we've talked about here on the record this morning, has anyone else, somebody besides your attorney, that's his role, has anyone else said anything to you about what your sentence might be as a result of entering this plea?
No.
All right. Ms. Hartley, are you aware of any other promises, threats, or inducements to the defendant? And counsel, how about you?
None, Your Honor.
Has the court complied with the court rule for taking the plea?
People are satisfied.
Counsel.
You have, Your Honor.
All right. Ms. Edie, do you have any questions now that we've almost completed this process?
I do not.
All right, last question. Do you want the court to accept your pleas here to 1 and 2?
Yes.
I will accept your pleas. You did offer those pleas freely, accurately, and voluntarily. So what you need to do now is check in at circuit court.
I have a question about the CCW.
Yeah.
Plea. Should that be held under advisement because a conviction will enter if we accept her plea today?
Under 771.1. But
What was that, Council?
We're
Doing a
requesting
delayed
under
Sentence then?
a delayed sentence under 771.
I thought that was just to count 2, the misdemeanor.
Two is 769.4A.
Okay.
And then the weapons charge was to be deferred for 6 months, and then it would be reduced to an improper transport.
So I think Ms. Vanderveen's correct, and the court will then hold off on accepting her plea to count 1. We can still do a PSI.
Correct.
Yeah.
Yes.
Okay. Is that what the parties anticipated?
Yes.
Does that alleviate your concern then?
I
think know
believe it does.
Where you're
yes.
going, yeah.
Yes.
Okay, I still need her to check in with circuit court probation before she leaves the building.
We'll do that.
And then when you return for a sentencing date, it's only gonna be about 4 weeks out. You do need to make sure that you bring money to pay those fines, costs, and other monetary obligations. You bring $500, that probably won't cover all of the monetary obligations, but I'll work with you on a payment plan to pay the balance. Of course, you're always free to bring more if you want to do that. All right, all set today.
Thank you, Aaron.
Okay, what else do we have?
As always, you guys are the best. Be safe, be well, sleep sweet, and much love.